people don't know about Sharia courts, how they fit into our legal system, who they apply to, or if they apply to everyone in Nigeria. Now follow me as I give you the gist. Hey guys, welcome to Legal Essentials, where we enlighten you on matters arising from the perspective of the law. If you're new to the channel, welcome, and if you're returning, welcome back. Please do well to like and also hit the subscribe button for more content like this. Sharia courts operate only in the northern regions, especially in 12 states, and apply only to those in these areas. In this video, I'll be unpacking the details such as a quick history of Sharia courts, their jurisdictions, type of cases they hear, the challenges they face, and the recent debates for and against the constitutional review on Sharia court law in the House of Representatives on October 2024. Some views in this debate as a push towards Islamizing Nigeria. But is that really the case? Before we dive into the sweet part of this bill that you are eager to hear, let's start with some essential insights about Sharia court, commonly known as Islamic law. Sharia court plays a significant role in the Nigerian legal system, particularly across northern regions. Historically, their roots are traced back to pre-colonial times. Islamic law governs many aspects of life in these areas, ranging from family matters to criminal cases. Since 1999, 12 Muslim-majority states, including Zamfara, Kano, Sokoto, Katsina, Bauchi, Borno, and Kaduna, have adopted Sharia as a central part of both civil and criminal law. This shift began with Zamfara's governor, Ahmed Sani, declaring full Sharia law, inspiring the other states to follow suit. These states went on to establish key Islamic institutions like Sharia commissions, Zakat commissions, and Hizbah Islamic police units. At its core, Sharia is a law for believers, meaning it mainly applies to those who embrace its principles. It's a system that combines moral standards of right and wrong, good and bad, setting a standard for how actions are judged for all human actions. The emergence of the Sokoto Caliphate in the 19th century AD gave the Sharia a new outlook altogether in Nigeria. It became supreme in every sphere of life: government, economy, foreign policy, administration of justice, and the organization of society. The merit of the Sokoto Caliphate experience lies not just in the conclusive proof it provided that the Sharia is for all times and for all people, but more fundamentally in the contribution to the conception of law and its utilization of political and social institutions of Islam to achieve maximum benefit for the Muslim community. According to Mohammed Bello, the state has the primary responsibility to examine critically the social and the moral conditions of its people on the basis of what it understands to be the purposes and the spirit of Sharia policies and legislations relevant to the issues. The state must review the Sharia law continuously, emphasizing aspects of it which have become important and put away the aspects that have become less important due to evolving nature of society. The state has the authority with the ability to evaluate the conditions of society from all perspectives. From a vantage viewpoint, is permitted to ignore the letter of the law in the favor of the spirit, if the occasion so demands. It is only in this way that fundamental objectives of the Sharia can be realized and the interests of humanities in general and the Muslims in particular safeguarded. Sharia courts fundamentally base their judgments on Islamic law, or Sharia derived from the Quran and the Hadith, that is story or sayings. Judges in Sharia courts are known as qadis. They interpret and apply Islamic principles. The existence of Sharia courts in Nigeria is predicated on our religious and cultural diversity. Sharia courts provide justice rooted in the cultural and religious belief for northern Nigerians, just as customary courts do the same for other regions. Sharia courts in Nigeria have a specific jurisdiction that distinguishes them from other legal systems in the country. Section 262, subsections 2 of the 1999 Constitution of the Federal Republic of Nigeria, as amended, provided for the jurisdiction of Sharia courts. They have the jurisdiction to handle civil cases related to Islamic personal law. These cases are typically related to personal issues such as marriage, divorce, inheritance, and other family matters. Now, these are the most common cases heard by Sharia courts. Marriage and divorce cases. One of the most common types of cases heard by Sharia courts involve marital disputes, including divorce, proceedings, and issues related to dowry payments. The second one is inheritance dispute. Sharia courts also handle cases related to inheritance, ensuring that Islamic laws regarding inheritance rights are upheld. The third one is family matters. Other family-related disputes such as child custody and maintenance are also within the jurisdiction of Sharia courts. And the last one is go. Muslim communities have access to justice aligned with their faith. Sharia court's jurisdiction differs from secular courts in Nigeria, which follow customary law or statutory law. While secular courts administer cases based on these legal systems, Sharia courts specifically apply Islamic law in their proceedings. Sharia court's authority is limited to access within their jurisdiction, mostly involving Islamic law. They do not have the authority to hear cases that fall outside this scope, such as criminal matters or commercial disputes. Overall, Sharia courts play a crucial role in the Nigerian legal system by providing a forum for Muslims to involve in disputes based on Islamic law. As stated earlier, Islamic law, also known as Sharia, is a system of law derived from the Quran and the teachings of Prophet Muhammad. Sharia judges, also known as qadis, are appointed based on their knowledge of Islamic law and jurisprudence. They have a deep understanding of the Quran and Hadith, as well as legal training. Sharia courts are guided by the following principles. 1. Adherence to Islamic law. What does this mean? Sharia courts apply Islamic law in resolving disputes. 2. Impartiality and fairness. Judges are expected to be impartial and fair in their decisions. 3. Compliance with legal procedures. What does this mean? Sharia courts follow established legal procedures in administering cases. 4. Respect for human rights. Human rights are protected and respected throughout the legal process. Here are the procedures followed in Sharia courts. Number 1. Case filing. Parties file their cases with the Sharia court, including all relevant documents. 2. Mediation. Parties may be encouraged to resolve their disputes through mediation. And number 3. Total proceedings. The trial to conduct with adherence to legal procedures and principles of Sharia. Number 4. Judgment. The Qadi delivers a judgment based on Islamic law and principles of justice. Every judiciary system has their controversies, and Sharia court is not an exemption. Listen to their controversies. Number 1. Gender discrimination. Sharia courts are often criticized for unequal treatment of women, especially in family law cases. Men tend to receive more favorable outcomes in divorce, custody, and inheritance cases, sparking concerns over gender bias that contradicts Nigerians' commitment to equality. Number 2. Harsh punishments. The use of corporal punishments like flogging and amputation in Sharia courts raises serious ethical concerns. Critics argue these punishments are harsh and incompatible with modern human rights standards, provoking debate about their place in civil society. Such punishments can be seen as cruel and inhuman. Number 3. Human rights abuses. There are reports of unfair trials, lack of due process, and limited legal representations in Sharia courts. Defendants often face unjust verdicts due to inadequate legal support, raising ongoing concerns about safeguarding fundamental rights within these courts. Next is legal inconsistencies. Sharia courts face challenges due to a lack of standardization. This inconsistency often leads to unpredictable legal outcomes and unequal access to justice depending on location, which raises concerns about credibility and reliability of Sharia legal system. Number 5. Constitutional debates. The capability of Sharia law with Nigeria's constitution remains a contentious issue. Critics argue that the implementation of Sharia law may conflict with constitutional guarantees of religious freedom and equality, potentially creating a parallel legal system which is capable of discriminating against non-Muslims. Influence on social norms. Sharia courts may play a significant role in shaping social norms within the Muslim community, but by upholding Islamic principles in family, personal conduct, and business matters. While this reinforces traditional values, critics argue it may pressure individuals to conform strictly to religious norms. The next one is promotion of Islamic values in law. By aligning legal decisions with Islamic teachings, Sharia courts aim to uphold Quranic principles and moral standards. However, this emphasizes on religious-based rulings raises concerns about the compatibility of Sharia law with Nigeria's legal framework, which then sparks discussion on the balance between religious and national law. Overall, while Sharia courts play a pivotal role in promoting Islamic values, supporting cultural identity, and providing a legal framework for Muslims, the controversies around fairness, human rights, and legal coherence spark significant debate on their role in Nigerian justice system. Now let's talk about the sweet part I mentioned before. As stated at the beginning of this digest, on 24th of October, the House of Representatives rejected a controversial bill seeking the expansion of the provision for Islamic law in the 1999 Constitution as amended. The bill, which was introduced by Aliyu Misau, a member representing Misau Damban Federal Constituency, Bauchi State, sought to amend Sections 24, Section 262, Section 277 and Section 288 of the 1999 Constitution by removing the word personal wherever it is mentioned from the section, allowing Islamic law to stand on its own. Section 262, subsection 1 of the Constitution provides the Sharia Court of Appeal shall, in addition to such other jurisdictions as it may be conferred upon by an Act of National Assembly, exercise such appellate and supervisory jurisdiction in the civil proceedings involving questions of Islamic personal law. The sections ordinarily restrict Sharia law to serve as a personal law on matters such as marriage, family, and/or estates. The controversial bill seeks to remove personal from Islamic law, thereby expanding its application from personal matters to other areas, such as commerce. The members supporting the bill argue that this will allow Islamic commercial and international law to flourish, citing the growth of Islamic banking, such as Jaiz Bank, as a modern development of which the Constitution did not anticipate. However, members who kicked against the bill, like Honorable Solomon Bob of Rivers State, that there is a reason the drafters deliberately use the word personal, and that if removed could have broader implications beyond what was intended. Also speaking, a PDP lawmaker from Osun State, Bamidele Salam, voiced opposition to the bill and urged caution in handling religious matters, given Nigeria's status as a secular state. He reminded legislators that this specific provision had previously sparked significant debate until it was held by the military intervention, with Islamic law restricted to personal matters such as estates. The member further emphasized the importance of avoiding constitutional amendments that could deepen societal divisions and noted that the proposed changes are largely addressed by the existing laws. After an intense deliberation, the Deputy Speaker, Benjamin Kalu, who presided over the plenary session, called for a voice note, which resulted in the rejection of the bill. While proponents of the bill may seek to reintroduce it upon a thorough review to refine their proposal, it is clear that for now the bill has been set aside and is no longer under consideration by the House of Representatives. Outside the House, religious leaders such as Bishop Matthew Kaku called the bill a dangerous precedent that threatens national unity. After hearing the above, do you think Islamic law should be restricted and confined as a personal law? Do you think the passage of the bill, if it wasn't rejected, could have led to any significant impact or consequence on the national unity of Nigeria, or simply a harmless tool to harmonize and foster advancement to Islamic law? Did you learn a thing or two about the Sharia courts? Let's know in the comment section. If you found this video helpful, make sure you like, share to friends, and subscribe to this channel. Thank you so much for watching this video. I remain your anchor, Ekem Nudo, and this is Legal Essentials.